When the law needed clarity, he wrote. When justice needed a voice, he spoke. A jurist with a variegated career spanning across 57 years as a part time professor, lawyer, High Court judge, Chief Justice of two states, a Supreme Court judge, and a trusted arbitrator. His pen, as C.K. Takwani, is as mighty as his gavel as C.K. Thakker. His books have received international appreciation from Sir William Wade, Lord Denning, and Justice Hidayatullah. It is truly our privilege to invite former Supreme Court Judge Justice C.K. Thakker. How are you, sir?
Thank you. Thank you very much. I am very fine.
Sir, this podcast will be divided into three components, where the first component will be pertaining to questions regarding you as a Supreme Court judge, second, with you as a renowned author, and third, with your expertise in arbitration. Moving ahead with the first component, I would like to ask, you have been a part time professor, a lawyer, a High Court judge, a Supreme Court judge, and an arbitrator, an illustrious career spanning across 57 years. What has your journey been like?
I may say that as far as I am concerned, I was the first generation lawyer because nobody from my family was a lawyer. I did my BA with economics and politics, known as entire economics. I wanted to do MA, but meanwhile, a professor, Professor P.T. Chaya, who was there in Jamnagar College, I was part-time lecturer in St. Xavier's Primary School. So one day he said that why don't you do LLB? And that was the first reaction on my mind that how I can go on. But then first lecture, law of torts, SB versus White and Demnum sine injuria sine demno, Mohri Bibi versus Dharamdas in law of contract, and constitution, we the people of India. So I was really happy. And that continued. I did my LLB, then I came here and I did my LLM also, and I started practice in High Court of Gujarat. After some time, I was appointed as part-time lecturer in law after completing my LLM, as also a public prosecutor, assistant public prosecutor, and I worked for about 7 years. In 1990, I was appointed as a judge in High Court directly. After 10 years, my promotion came and I became Chief Justice of Himachal Pradesh. And thereafter, I was transferred at the instance of Justice Bharucha. He said that you may go to my parent court. So I became Chief Justice of High Court of Bombay. For some time, I was governor also. And then I went to the Supreme Court and I retired in 2008.
Sir, it is truly remarkable to see how each and every step has enriched the next. Building on that, I would like to ask, if today a young advocate wanted to argue before the Honorable Supreme Court, what is expected of him by the judges?
As far as Supreme Court is concerned, I am confident and I have experience also that judges read the matters. So they are very well versed with facts as well as law. But as you say with regard to lawyers, my advice is that he must read his papers, he must be very clear on facts, and he must put it properly, he must understand the legal position, and he may argue the matter before the court.
That's a very practical insight, sir. But in today's time, judges face dilemmas too. So, how does a judge navigate through the delicate balance between their own personal beliefs and the demands of interpreting the law strictly?
As it is said, all judges are also human beings. So they have also their views. But as it is said, and generally High Court, Supreme Court, they take oath also that they will act in a consonance with law and uphold the constitution and laws. So they are aware. Sometimes they feel that I may decide one way or the other, but he may not be allowed to go if the law says otherwise. So maybe his personal views, but he will decide in accordance with law.
That insight is very reassuring, sir. But misconceptions about judiciary still exist. Have you encountered certain misconceptions about the judiciary that you would like to debunk?
There also I tell you that sometimes such impression is created, but it is not so. The reason is that sometimes, say for example, criminal cases, sometimes as far as our moral, say, is concerned, or our views are concerned, prima facie we feel that he might have committed an offense. And you also must be aware that sometimes even confessions are also there. But such confessions may be either before police officer or certain circumstances, but then when they are not admissible in evidence, the court will have to acquit the accused. So such questions may happen. But ultimately, the judge will decide according to law.
That clears a lot of doubt, sir. Now, shifting the perspective a little, if today a lawyer wanted to become a judge one day, what qualities and achievements are required for him?
See, in fact, I have always believed, and even now I am of the view that we all are students of law. So, as students, you will study and you will study properly. So, first advice is that study. Read, and read. Read, and if my advice is to be taken, then write also. If you write, it will be much more effective. And then, whenever your any cases comes to you, then you may properly study, put before the court effectively, get the decision maybe in your favor or against you. And if you do it politely, if you do it, say, with the satisfaction of the court, it may go a long way, and maybe that you may be taken to judiciary.
That's very motivating, sir. Sir, you have been known to prefer writing your judgments rather than dictating them on open court. What is the reason behind this?
Now that practice has slowed down, but practice, as far as I know, practice of Bombay High Court and ultimately Gujarat thereafter from 1960, the practice was that as soon as the matter is over, the judge will call stenographer and he will give judgment, which is known as oral judgment. Immediately it was given. And the reason is that one thing is that immediately the matter is over, both the sides are aware also, they get judgment, and your work is also over. But due to now several cases before several courts, now that practice has been limited to some extent. As far as Supreme Court is concerned, I am aware also, Supreme Court is concerned, Supreme Court, unless only that SLP is dismissed, even a small order, they are not dictating in court. The reason is that Article 141 says that it is the law of the land. So, Supreme Court judge, every judge, he considers that it is better that I keep the judgment or order reserved, apply my mind, and decide that afterwards.
That makes sense, sir. Moving ahead, certain judges like Justice Krishna Iyer and Lord Denning are still remembered decades after their tenure. What makes a judge so distinguished to be remembered even after their tenure?
You are right, but both were really jurists. And fortunately, I had relations with both of them. Of course, as far as Lord Denning is concerned, I could not see him. But Justice Krishna Iyer, I knew him, and he completed 100 years. So he was, say, a human, say, great human being, an excellent judge. And again, say, he was taking keen interest in all matters. As far as Lord Denning is concerned, I knew him only by correspondence and everything. He had invited me to London also, and he said that we may hold meeting and I will introduce you with, at that time Privy Council was there, House of Lords were there. I could not go. But he was always very kind to me. It was a personal experience to me also. In fact, as far as my administrative law is concerned, he said that at the age of 92 and a half, I am keeping your book on my table, though I am having several rooms, and my library consists of law reports of 400 years. When I wanted to dedicate law of writs revised by me to Lord Denning, I thought that I must first get leave, permission from him. So I wrote a letter, and those were not the days of email and everything. But he agreed, and he was very happy, and he said that it would be my pleasure if you dedicate your work to me. And I did it.
With that, sir, this brings us to the second component of the podcast, and I would like to ask, why do courts dedicate so much time in the procedural nitty-gritties? Why can't they just brush them aside and focus on the merits of the case?
Procedural aspect cannot be ignored. It is true that ultimately substantial justice must be done. But if it is a civil matter, you will have to keep in mind provisions of the Civil Procedure Code and partly Evidence Act also. If it is criminal, provisions of Criminal Procedure Code, now new Act, BNNS, then Evidence Act, BSA, and then decide. But you cannot ignore them.
I understand, sir, but don't you think justice delayed is justice denied? And with this, the courts are getting bogged down into technicalities.
It is true that justice delayed is justice denied. Nobody can dispute this proposition. But you will have also to consider several facts. Say, for example, before 50, 60 years, crimes were not that much. Civil litigation was also not that much. See, that has been increased. Thirdly, people have also become now educated. They are aware of that right. Such situation was not there, and particularly in villages. So in view of increase of litigation, in view of several disputes and several quarrels, civil as well as criminal, it has resulted in delay. And it is true that as far as possible, we will try to give in accordance with law, but procedure cannot be ignored.
That's an important perspective, sir. Sir, since you have written so extensively upon administrative law, how do you think administrative law has shaped itself to adapt to the evolving needs of the society?
See, as far as administrative law is concerned, it is like law of torts. There is no administrative law like civil procedure, criminal procedure, specific relief act, contract act. So it is unwritten law. But unwritten law also, it is really part and parcel of constitutional law. And administrative law has encroached virtually, if it can be said, civil litigation, criminal litigation, service litigation, and other litigations also. For instance, several doctrines, doctrine of promissory estoppel, doctrine of legitimate expectation, and all other doctrines, proportionality, all is part and parcel of now administrative law. So administrative, and one thing is what I feel is that day by day, that litigation on administrative law will still be more.
That is very enlightening, sir. Speaking of your writings, how did you find so much time as a judge to author and publish so many works?
Really, as a judge, I must admit that I was a traditional judge or conservative judge. I was not going anywhere. In fact, this question was put to me during this COVID time, when I was appearing, I was addressing them through online, virtual medium. And along with me, Justice Akhil Qureshi was there. And this question was put to me, and Justice Akhil Qureshi had replied, and I agreed with it. He said that even in the Supreme Court, after Friday, that is normally SLP days, and normally by lunchtime you are free. So I enter my, of course, government bungalow, but I enter my bungalow. And then it opens on Monday. So I don't go anywhere, not even for walking, even in garden also. So my work was only reading, and writing. So that gave me time.
Sir, that discipline is clearly reflected in your books. And with that, I would like to ask, how do you make legally dense topics simpler for students?
What I do is, even now, I tell you frankly, even now, I write by hand, and that is also with fountain pen. Thereafter, I read, and no exaggeration. Sometimes I read 5 times, 6 times, sometimes even 10 times. So, as and when I read and reread, not that I have committed an error or committed mistake, but I think that instead of this sentence or instead of this phrase or instead of this word, other would be better. And that is how I say that. And simplicity must be there. So I always believe that when you write something, you say, for example, paraphrase judgment of the Supreme Court, as far as possible, you may take down the ratio. But at the same time, it must be placed or it must be put in that language that a student also can be able to understand.
That's a wonderful method, sir. But for students who want to master CPC, how should one actually study CPC?
In our LLB, up to LLB level, I had not studied civil procedure. Some other laws which may not be that much important, private international law, public international law, they were there. CPC was not there. When I came here and I was prosecuting further study for taking sanad in Bar Council, Civil Procedure Code was there. Now, I was not knowing that Civil Procedure Code had some provisions which can be said to be substantive provisions, other provisions which can be said to be procedural. They are in the form of orders and rules. So, when I distinctly recollect, and I may tell you, Section 96 was studied by us. The professor, we were not having books also. So he said that first appeal and this is the position, and second appeal and this is the position. After several periods, again he said memorandum of first appeal. So I was surprised that what is this first appeal? We have already studied. And I was surprised, the professor who was also a practicing lawyer, he said that, yes, what is the trouble with you? I said that, sir, my note, because I was a regular student, my note shows first appeal is discussed. Gentlemen, there is difference between substantive law and procedural law. Now, I really thought that it is better that when students want to study civil procedure or student want to study a particular act or particular law, he must proceed in systematic matter. And that is how I wrote that civil procedure.
Sir, this brings us to the third component of our podcast. And I would like to ask, arbitration was meant to be cost effective and provide speedy disposal of cases, but that seems far from a dream. How do you envision arbitration to save this from its sinking boat?
See, I may say that even arbitration also, I have conducted several arbitration proceedings also. Not only national but international. And in many matters, I was sole arbitrator. In several matters, I was presiding or other arbitrators. And it cannot be said that, yes, the intention was that it must be disposed of as early as possible. It could not be done. Act was amended also. But see, most of the reason is that most of the lawyers are appearing and they take several contentions. And most of the even arbitrators are also, though others may be appointed and may be nominated, but you must be aware that many of them are judges. So they also know their duty. Advocates also do not leave the matter. So several points they are taking, and it results in delay sometimes. Of course, now you must be aware that even time limit and everything is provided. But it is true that there is delay.
That is a candid assessment, sir. So compared to your judicial role, how did your tenure as an arbitrator differ from your tenure as a Supreme Court judge?
Several questions which came up before me as sole arbitrator or in 3 benches, They never came when I was a judge, because my career was about 19 years. And as it is said that 4 courts, including the Supreme Court, but still certain questions had not come before me, even as a judge of the Supreme Court. And this commercial litigation, and particularly sometimes it is technical also. So these technical questions come only when I was an arbitrator. And we frankly say, if I am sole arbitrator, as arbitrator, or 3 arbitrators, we say that please explain us. Say, for example, ONGC contract. Several such questions arose which were not before. We have never studied during our either as lawyers or judges. So such questions come, and we say that we are students, please explain us.
Sir, speaking of how arbitration brings unique challenges, what is your stance on the modification of arbitral awards?
You will have to keep in mind that you must be aware that it is a private tribunal. It is not, say, state agency or court created by Crown. So both the parties have gone there. So first of all, you will have to proceed in that direction, that both the parties have chosen their arbitrator, maybe sole or 3. So first of all, with that, as far as possible, the chances would be less and party may not go to the court. But parties will certainly, losing party, and we cannot find fault with them also. So he will go to a court. But then law has also taken care. It is not like Section 96 first appeal, that all questions of fact, questions of law, so mixed questions of law and fact, everything is available. No, very limited. But sometimes courts are also liberal. One. Secondly, sometimes it also happens that arbitrators have not decided strictly in consonance with the principles of law, and that is how the matters go to court also. Otherwise, courts are taking care of it. But the courts are also taking care of justice.
That gives a lot of clarity, sir. So, with that, I would like to ask my final question. What is one advice that you would like to give to the future judges of India?
See, as it is said, we have played our innings. But whenever I go to either grassroots level, that is civil judges and magistrates, or even judges, district judges, and even high court judges in this Bhopal, etc., I say that as far as judicial function is concerned, first of all, it is said that it is a sovereign function. Because otherwise, disputes between 2 parties, how can you say something about it? Dispute between, say, accused and victim, how you are having any authority? So, it is sovereign function of the state which is entrusted to you. So, keep in mind that it is sovereign function. But then second is also there, and I say that you must emphasis on that part, and that is divine function. See, as far as the sovereign function is concerned, sovereignty, something like authority, something like power. So I say them that you please ignore this. You must find that it is divine function, divinity. And if you consider that fact, then you will exercise your power, discharge your duties with full satisfaction, and God also will be happy.
Sir, thank you so much, sir. It was really a privilege of having you with us.
Thank you.
It was really great to hear.
Thank you.
Thank you so much, sir.
Thank you.